Hello, friends. Namaste. A few weeks back, I had delivered a lecture on Indian judiciary in Malayalam. Some of my friends felt that it should have been in English. Hence, I am making another attempt. Consider the bold proclamation from a character in a Malayalam film released nearly a year ago. In that case, you file a case against me. That was the title. Though I haven't seen the film myself, the essence of this challenge is unmistakable. It speaks volumes about an individual's confidence in their untouchability within our legal framework, a brazen defiance born from the belief that consequences will not follow. Our judicial hierarchy, with the Supreme Court at its zenith, followed by high courts and district courts, is currently overwhelmed. As of 2024, an estimated 5.1 crore cases remain unresolved, with a staggering 87% clogging the arteries of our district courts, land disputes making the bulk of this backlog. A poignant example from Bihar in April 22 saw an individual acquitted of a murder charge after 28 years due to insufficient evidence. The Niti Aayog's strategy paper grimly forecasts that clearing this backlog could take up to 324 years. Such statistics lend credence to the audacious challenges thrown in our courts' faces. Clearing this mountainous backlog is an arduous task, and expecting swift resolutions is perhaps naive. When we read about cases like Lavalin being postponed for the umpteenth time, it is easy to suspect undue influence. It is simply the machinery of justice grinding too slowly. When we read about cases like Lavalin being postponed for the umpteenth time, it is easy to suspect undue influence. It often it's simply the machinery of justice grinding too slowly. My personal odyssey through this labyrinth echoes similar themes. In the infamous Pamelin case, which dates back to 1991, it took 8 years just for an FIR to be lodged against key figures, including former chief minister, ministers, high ranking officials, foreign entities, Mr. PJ Thomas, former food secretary, and me. Decades later, many of those accused have passed away, yet the case languishes in judicial limbo. The trial court has not even framed the charges despite a passage of 25 years. My appeal to the esteemed Supreme Court has sat idle since 2010, awaiting its day in court. It brings to mind the adage, justice delayed is justice denied, a phrase that resonates all too well with those ensnared in this judicial quagmire. During a sojourn abroad, I had the fortuitous opportunity to observe the inner workings of a foreign court, a stark contrast to what I had known back home. My guide through this enlightening experience was Mr. Saju Jacob, a seasoned attorney in Cologne, Germany, who now practices in the Supreme Court of India with his expertise. Mr. Jacob represented an NRI client embroiled in a grievous car accident case, one that tragically claimed a life. I accompanied him to court. where we were greeted not by a retinue of aides, but by the judges themselves, three dignified figures unencumbered by excess, carrying their own law books and keys. The proceedings commenced with a heartfelt expression of condolence for the loss of a young life, a poignant moment that underscored the court's humanity. Yet, impartiality remained paramount as they acknowledged the victim's inebriation as a contributing factor to the accident. A dialogue ensued between the parties, with the court gently steering them towards an amicable resolution. Initial reluctance from both the accused representation and insurance gave way under the court's reasoned persuasion, culminating in an agreed compensation of €500. This swift and compassionate approach left me pondering. When might we witness such expediency and empathy in our nation's accident cases? How long must one wait for even a chance at hearing? The hallowed halls of our Supreme Court echo with deference, my Lord. Yet one wonders if divine intervention is needed for relief from our protracted legal battles. An independent judiciary is vital for a healthy democracy. It serves as the Constitution's guardian, ensuring constitutional laws and actions and maintaining a balance of power. It checks against government overreach, protects individual rights, upholds the rule of law, and ensures equality before the law. With judicial review, it can invalidate unconstitutional laws, shaping the legal framework and holding all government branches accountable. Ultimately, it defends democratic values and civil liberties, ensuring justice for all. The question of judges transitioning into political roles is a complex and multifaceted issue. Let us explore the various aspects. The number one is a legal perspective. The Indian Constitution doesn't explicitly prevent judges from joining politics post retirement. Recent cases like Justice Gangopathyay's have sparked debate on the need for a cooling off period. 2. Rule of law and separation of powers. Judges' transition to politics could blur lines between law interpretation and creation, affecting the rule of law. It may also compromise the separation of powers essential for democracy. 3. The constitutional perspective. The Constituent Assembly didn't explicitly bar judges from executive roles post retirement, but recent events suggest a re evaluation is needed. 4. Maintaining judicial neutrality. Judges are expected to be neutral. Political affiliations could bias their law interpretation. 5. Oath and ethical principles. Judges' oath emphasizes independence and impartiality. Political activities could undermine this. 6. Preserving judicial dignity. Upholding judicial reputation requires a clear separation from politics. Legislation or ethical guidelines might be necessary to ensure accountability and transparency. In essence, while not legally prohibited, Judges' entry into politics after retirement raises significant concerns about maintaining judicial integrity and democratic values. The intersection of judges and politics has been a topic of interest throughout history. Here are some notable examples. One is Justice Koka Subbarao. He resigned as CJI to run for president, raising ethical questions about the judiciary's involvement in politics. Second is Justice Baharul Islam. He stepped down from the Supreme Court to contest Lok Sabha polls, showcasing the complexities of judicial political engagement. There are many other instances. Supreme Court judges have resigned to enter elections, highlighting a trend of judges moving into political spheres. A former chief election commissioner became a Rajya Sabha member and minister post retirement. A retired CJI was nominated to the Rajya Sabha shortly after retirement. Retired CAG officials and judges have been appointed as governors. These cases underscore the ethical dilemmas faced when judges transition into political roles and the importance of maintaining judicial independence while considering political engagement. Let's now look at how other countries handle this issue. The approach to judges entering politics varies from different countries. Let us now look at how other countries handle this issue. The approach to judges entering politics varies across different countries. In the United States, judges are often elected, allowing citizens to choose based on political affiliations and qualifications. In the United Kingdom, judges are appointed by the monarch on the Prime Minister's advice, striving for judicial independence. In India, of course, judges are appointed by the President, following recommendations from the collegium system, focusing on legal expertise. In the European Court of Human Rights, judges are appointed by member states. They may reflect preferences for European integration. In Germany, federal judges are appointed for life by the federal president after being elected. Other countries like Argentina, Australia, Canada, and others, they use governmental appointments for selecting judges. Each system aims to balance judicial independence with political considerations and public trust in varying degrees. Let us explore some historical examples of judicial appointments in India, both successful and problematic. In the pre-collegium era, appointments were sometimes seen as nepotistic. An independent judiciary was preferred over a judicial aristocracy. And then came the collegium system. The system evolved to balance executive and judiciary powers. The 1973 appointment of the CJI, bypassing senior judges, raised concerns about judicial independence. The three judges' cases led to the collegium system, emphasizing the CJI's recommendations. The collegium system is criticized for its lack of transparency and potential nepotism. Judicial appointment practices vary globally, balancing independence and political considerations. And striking a balance is key to maintaining public trust and judicial integrity. In essence, India's shift from collaborative appointments to the collegium system highlights the ongoing struggle to preserve judicial independence alongside transparency and accountability. We have had many examples of fiercely independent judges. The first name that comes to my mind is that of Justice H.R. Khanna, remembered for his dissent in the ADM Jabalpur case. He defended individual liberties against political pressure during the emergency at the cost of being superseded for the post of Chief Justice of India. Then comes Justice P.N. Bhagavati, who advocated for public interest litigation. Then Justice B.N. Srikrishna, known for his clear and firm judgments. He headed the famous Sri Krishna Commission that investigated the 1992 Bombay riots. Justice Roma Paul, renowned for her strong, independent stances, she consistently upheld constitutional values and human rights. Justice V. R. Krishnaiyer, he was known for his progressive judgments and was key in advancing public interest litigation in India. And now, Justice Dhananjaya Yashwant Chandrachud. Justice Chandrachud's leadership in the judiciary is marked by his commitment to upholding the Constitution and ensuring justice for all. These judges stand as pillars of judicial independence, ensuring the protection of citizens' rights and the rule of law. Of course, there are many examples of fiercely independent judges from various countries, like Justice Albie Sachs of South Africa, Justice Aharon Barak of Israel, then Justice Ruth Bader Ginsburg of the United States. Justice Rosalind Higgins of the United Kingdom is another famous judge. Her rulings on international disputes have significantly impacted international law and emphasized judicial independence. These judges are celebrated for their dedication to justice, human rights, and upholding constitutional principles, inspiring judicial independence globally. Now, we come to the question, how can we, the ordinary citizens, actively support judicial independence? You know, citizens play a crucial role in supporting and safeguarding judicial independence. Here are some ways they can actively contribute. Number one, awareness and education. Stay informed about the judiciary's role, functions, and significance. Educate others about the importance of an independent judiciary in upholding democracy and the rule of law. 2. Advocacy and public discourse. Engage in discussions about judicial independence in public forums, social media, and community gatherings. Advocate for transparency, accountability, and reforms that strengthen the judiciary. 3. Support legal literacy programs. Promote legal awareness among citizens, especially marginalized communities, and encourage participation in legal literacy workshops and programs. 4. Monitor judicial appointments. Stay informed about the appointments, transfers, and retirements of judges. Raise concerns if appointments lack transparency or appear politically influenced. 5. Defend judicial autonomy. Speak out against interference by the executive or other branches of government. And support judges who uphold constitutional principles and independence. 6. Participate in public interest litigations. File PILs to address issues related to justice, human rights, and constitutional violations. Support PILs that promote transparency, accountability, and judicial integrity. 7. Promote legal ethics and professionalism. Encourage ethical behavior among legal professionals. Hold lawyers and judges accountable for any misconduct. 8. Respect court orders. Comply with court orders and respect judicial decisions. Uphold the sanctity of court proceedings. 9. Media and public perception. Support responsible journalism that highlights judicial independence. Challenge misinformation that undermines public trust in the judiciary. And 10. Participate in judicial reforms. Advocate for reforms that enhance judicial efficiency, reduce delays, and improve access to justice. And also push for better infrastructure and resources for courts. Remember, an independent judiciary benefits everyone, and citizens' active involvement ensures its continued strength and integrity. Before I stepped up to the microphone, a chum of mine lobbed a curious question my way. Gigi, what is on the docket for your next oration? I said, I'm mulling over a discourse on the Indian judiciary. His eyes widened. Are you sure that is wise? What if they slap you with a contempt of court? You could end up behind bars. I chuckled. Oh, fret not. Even if they did haul me to court, the wheels of justice turn at such a leisurely pace, I would be long gone before they could even bang the gavel on my case. So why lose sleep over it? Thank you, ladies and gentlemen, for your time and patience. See you next week.